Hello and welcome to Law Logical, your weekly guide to understanding the laws of the land. Today we dive into the complex world of Indian family law. We're going to unravel the legal intricacies surrounding the rights of children born through extramarital or live-in relationships in India. Our aim? To provide a simplified yet comprehensive explanation of this sensitive issue, helping you understand the legal rights that protect these children. Stick around as we unravel this intricate aspect of Indian family law. To understand the rights of children born in extramarital/live-in relationships, we first need to understand what these relationships mean under Indian law. An extramarital relationship, as the term suggests, occurs when a married individual engages in a relationship outside of their marriage. This could be with a single person or another married individual. On the other hand, a live-in relationship refers to an arrangement where two individuals, not married to each other, live together in a long-term relationship that resembles a marriage. These relationships, though common in many parts of the world, are often met with societal skepticism, especially in traditional societies. But what does the Indian judiciary say about these relationships? The Supreme Court of India, in a landmark judgment, recognized live-in relationships as a part of the right to life under Article 21 of the Indian Constitution. It stated that live-in relationships are permissible. There is no law prohibiting it, and it is an individual's right to choose their partner. For extramarital relationships, however, the legality is complex. Adultery was decriminalized by the Supreme Court in 2018, but it still remains a valid ground for divorce under the Hindu Marriage Act, 1955, and the Special Marriage Act, 1954. It's important to note that the legal recognition of these relationships doesn't necessarily mean societal acceptance. There are still many cultural and societal hurdles that people in these relationships need to navigate. In terms of the rights of partners in live-in relationships, the Domestic Violence Act of 2005 provides certain protections. The Act acknowledges that a relationship in the nature of marriage can exist even without a formal ceremony and provides legal protection against abuse and violence. Now that we have a basic understanding of these relationships, let's move on to the rights of children born in such circumstances. Children are the most innocent parties in any relationship, but what happens when they are born out of an extramarital or live-in relationship? This question brings us to the heart of the matter. In India, the law turns a compassionate eye towards children born from such relationships, ensuring they are not disadvantaged due to circumstances beyond their control. We'll look at three primary rights of these children: inheritance rights, maintenance rights, and the right to know their parents. When it comes to inheritance rights, the Indian law has evolved to ensure that children born out of wedlock are not deprived. The Hindu Marriage Act and the Indian Succession Act are two key pieces of legislation that address this issue. According to these laws, a child, whether born in a wedlock or not, has the legal right to inherit the property of his or her parents. This applies to both movable and immovable assets. However, it's important to note that these rights come with certain conditions. For instance, the parents must have been in a relationship that resembles a marriage, even if they were not officially married. This is a complex area of law, but the key takeaway is that inheritance rights are not automatically denied to children born out of an extramarital or live-in relationship. Next, let's discuss maintenance rights. These are crucial for the well-being of the child. Under Section 125 of the Code of Criminal Procedure, a child, irrespective of his or her legitimacy, has the right to claim maintenance from his or her parents. This is irrespective of whether the child is a minor or has attained majority but is unable to maintain himself or herself. The law mandates that it is the responsibility of both parents to provide financial support for their child's upbringing. Finally, there's the right to know the parents. This is a fundamental right of every child, regardless of the circumstances of their birth. While this may seem self-evident, it is significant because it affects the child's identity and sense of self-worth. However, it's worth mentioning that this right is often difficult to enforce in practice, especially in cases where one or both parents deny paternity or maternity. In conclusion, the rights of children born out of extramarital or live-in relationships are recognized and protected under Indian law. While there may be societal stigma attached to these circumstances, the legal system strives to ensure that these children are not disadvantaged in any way. The law acknowledges that every child, regardless of their birth circumstances, deserves to be treated with dignity and respect, and to have the same opportunities as any other child. These rights are designed to ensure that every child, regardless of the circumstances of their birth, is protected. Indian courts have dealt with numerous cases involving the rights of children born in extramarital or live-in relationships. Let's delve into a few landmark cases that have significantly shaped the legal landscape concerning the rights of these children. One such case is the well-known Tulsa versus Durgatia case. In this case, the Supreme Court recognized the rights of a child born out of a live-in relationship, stating that he or she cannot be termed illegitimate. The court declared that if a man and woman are involved in a long-term relationship, the law will presume the couple to be legally wedded. This was a significant decision that set the tone for future judgments. Then we have the Ravana Siddhappa versus Mallikarjun case. Here, the Supreme Court ruled that children born out of live-in relationships have the same rights of inheritance in their parents' property as those born within wedlock. This was a monumental judgment, as it provided a safety net for such children who were earlier not legally recognized. In the Madan Mohan Singh versus Rajnikant case, the court once again reiterated that a child born out of a live-in relationship is not illegitimate. The court held that the child has all the rights that a child born to a married couple has, including the right to inherit the parents' property. In the Bharata Mata and Ors versus R. Vijaya Ranganathan and Ors case, the Supreme Court stated that a child born out of a live-in relationship is not only entitled to inherit the property of the parents, but also has the right to claim a share in it. This ruling further cemented the legal status and rights of children born in live-in relationships. Finally, the Indra Sama versus VKV Sama case is worth mentioning. The Supreme Court in this case defined the term relationship in the nature of marriage and stated that if certain conditions were met, a live-in relationship would be considered equivalent to a marriage, thereby granting the child born out of such a relationship the same rights as a child born out of a lawful marriage. These cases demonstrate the evolving nature of Indian law in protecting the rights of all children. They have played a pivotal role in ensuring that children born out of extramarital or live-in relationships are not discriminated against and are accorded the same rights and protections as children born within wedlock. So, that was a simplified explanation of the rights of children born in extramarital/live-in relationships under Indian family law. We've journeyed through quite a lot today, haven't we? Let's take a moment to revisit some of the crucial points we've discussed. We began by understanding the complexities of extramarital and live-in relationships, diving into the nuances and realities of these relationships in the context of India. We then moved on to a crucial topic: the rights of children born in these relationships. We discovered that despite the unconventional circumstances of their birth, these children are entitled to the same rights as any other child, according to Indian family law. They have the right to maintenance, inheritance, and most importantly, they have the right to a life of dignity and respect. Our discussion further led us to some real-life case studies and precedents that have shaped the current legal perspective on this issue. These cases have not only helped in providing justice to the individuals involved, but have also contributed to the broader discourse on child rights in India. But why, you may ask, is all this so important? Well, understanding these laws is integral to ensuring the protection of children's rights, regardless of their parents' relationship status. It helps us to safeguard their interests and ensure that they are not denied the love, care, and support they rightfully deserve. We hope this video has shed some light on this often overlooked aspect of Indian family law. Remember, these laws exist to protect the most vulnerable among us, and understanding them is the first step towards ensuring justice. Thank you for joining us on Law Logical today. Don't forget to like, share, and subscribe to our channel for more content like this. If you have any questions, feel free to drop them in the comments section below. And remember, knowledge of law is power. See you next week with another interesting topic.